Chiming Choi versus Court of Appeals and Gina Lau Choi. This case is under Article 36 Family Code of the Philippines. The facts of the case are as follows. Chiming Choi and Gina Lau Choi got married on May 22, 1988. Although they slept in the same bed, but no sexual intercourse took place, that as newlyweds, they were supposed to enjoy making love or having sexual intercourse with each other. The defendant just went to bed, slept on one side thereof, then turned his back and went to sleep. There was no sexual intercourse between them during the first night. The same thing happened on the second, third, and fourth nights. Gina claims that the chiming is impotent, a closet homosexual, and that the defendant married her to acquire or maintain his residency status here in the country and to publicly maintain the appearance of a normal man. Gina is not willing to reconcile with her husband. Chiming admitted that they have not had intercourse since their marriage until their separation because his wife avoided him. The defendant submitted himself to a physical examination for the purpose of finding out whether he is impotent. The doctor found out that from the original size of 2 inches or 5 centimeters, the penis of the defendant lengthened by 1 inch and 1 centimeter, that the defendant had only a soft erection, which is why his penis is not in its full length. But still he is capable of further erection, and that with his soft erection, that the defendant is capable of having sexual intercourse with a woman. Trial court declared the marriage void. On appeal, the Court of Appeals affirmed the trial court's decision. What is being resolved here, in this case, is whether or not the appellant is psychologically incapacitated to discharge a basic marital obligation. The court ruled yes. Senseless and protracted refusal to consummate the marriage is equivalent to psychological incapacity. Chiming Choi admitted that he did not have sexual relations with his wife after almost 10 months of cohabitation, and it appears that he is not suffering from any physical disability. Such abnormal reluctance or unwillingness to consummate his marriage is strongly indicative of a serious personal disorder, which to the mind of the court clearly demonstrates an utter insensitivity or inability to give meaning and significance to the marriage within the meaning of Article 36 of the Family Code. Petitioner further contends that the respondent court erred in holding that the alleged refusal of both the petitioner and a private respondent to have sex with each other constitutes psychological incapacity of both. However, neither the trial court nor the respondent court made a finding on who between petitioner and private respondent refuses to have sexual contact with the other. But the fact remains that there has never been coitus between them. At any rate, since the action to declare the marriage void may be filed by either party, the question of who refuses to have sex with the other becomes immaterial. One of the essential marital obligations under the Family Code is to procreate children based on the universal principle that procreation of children through sexual cooperation is the basic end of marriage. Case at bar, the senseless and protracted refusal of one of the parties to fulfill the above marital obligation is equivalent to psychological incapacity. Hence, the petition is denied by the Supreme Court of the Philippines.